Mr. President and members of the Court, it is common ground between Belize and Honduras that the context of this application involves unique features. Those features have not arisen in the decided cases. From Belize's perspective, there are two such features. The first is the existence of a parallel case in which the applicant for intervention has been and will continue to be fully heard. The second and related feature is that the applicant for intervention agrees that there should be coordination between the two cases such that the court's deliberations will overlap. Bearing in mind those unique features, Guatemala evidently heard both Belize and Honduras say yesterday that it was entirely unclear precisely what Guatemala thought informing the court of its interest and protecting that interest would involve in concrete terms. The court might have expected that, prompted by those submissions and by the court's approach in Indonesia-Malaysia, Guatemala might return this morning with a detailed list of issues and documents. The court might have expected Guatemala to explain how such issues and documents were or should be examined in Belize, Honduras. The court might have expected Guatemala to explain how such examination may affect Guatemala's interests. The court might have expected Guatemala to explain how it had not had and would not have an opportunity to be heard on such issues and documents in Guatemala, Belize. Not only did we not hear a list, we did not hear a single example. We heard this morning instead that this case created a new dimension and that Guatemala would provide its views and give proper context. We were promised a full picture, relevant documents, and a perspective. The court has Belize's submissions on the 4 notes verbal that Guatemala was able to mention on Monday, and this morning we heard no reply on those. We also, more importantly, heard nothing about any other document that Guatemala might have that it would wish to place before the court in this case to inform the court and protect Guatemala's interests. The court does not deal in generalities. It deals in facts and law, and Guatemala has not indicated with even the bare minimum of specificity any of either that it would contribute to the present case. The court was instead told this morning, as it was on Monday, that it is just obvious that Guatemala should be permitted to intervene because the 3 states claim the same territory. Guatemala told you that this was a textbook example of a case for which Article 62 of the statute was designed. That might be so if the Guatemala-Belize case did not exist. But in light of the unique features we identified, it is not enough to meet Guatemala's burden in the very particular circumstances of this case. Those features are not in the textbooks. Notwithstanding the reference to textbooks this morning, the court will have noticed that Guatemala had no response to offer on the submissions of Belize and Honduras on the Gulf of Fonseca case and the Eritrea-Yemen arbitral award. I will add only 2 points on those arising from the submissions of Honduras. The first is that Honduras is quite correct to say that insofar as the Gulf of Fonseca case concerns a right to be heard, Guatemala is being heard in its case with Belize. The second is that if one were to change the facts of this case to make it more like Eritrea, Yemen, the question would be this. If Belize and Honduras, instead of turning to the court, had signed a treaty by which they agreed that Belize was sovereign over the Sapodilla Cayes, would that have any legal consequence for Guatemala? If one then steps from that analogy back to this case, the conceptual position is the same. The court will recognise that this is not my analogy, but the court's own explanation in Burkina Faso, Mali. Guatemala's only response to that is its refrain that a judgment can affect the legal interest of a state without being binding on it. Even if that were correct in principle, it is vastly insufficient to establish why the very particular circumstances of this case justify intervention. Members of the court, doubtless with that problem in mind, you heard from Guatemala this morning that there was not enough time for Guatemala to comment on this new case in its reply in the other case. And that leads me to read out paragraph 7.29 of Guatemala's reply. It says this: Honduras has also claimed the Cayes Sapodilla Cayes since 1981, according to Belize's application of 16 November 2022 in the case concerning sovereignty over the Sapodilla Cayes, Belize, Honduras. In this document, Belize requests the court to adjudge and declare that as between Belize and Honduras, Belize is sovereign over the Sapodilla Cayes. As is shown in the present chapter and in chapter 10 of the memorial, Guatemala has title to the islands of the Bay of Honduras not included in the Anglo-Spanish treaty arrangements. These islands include the Cayes Sapodilla Cayes. Belize's application against Honduras does not change anything in this respect. Members of the court, Guatemala was absolutely right that the present case does not change anything in respect of Guatemala's claim against Belize. And Guatemala confirmed this morning that it makes no claims of sovereignty against Honduras. That rather leaves one wondering why exactly Guatemala wishes to intervene in this case and what exactly it would do in concrete terms if it were permitted to do so. Guatemala has not answered those questions with any degree of specificity. The court will recall that yesterday Honduras suggested that there could be a third round of written submissions in Guatemala-Belize instead of intervention in this case. Guatemala stated this morning that this was out of the question and totally unrealistic. Belize certainly agrees with Guatemala on that point, which raises the broader issue of time and resources. In considering the issue of potential intervention in this case, the court should, in Belize's respectful submission, be sensitive to the additional burden that would place on the parties in terms of time and resources. Belize and Honduras agreed that there should be only one round of written submissions in this case. They did so for good reasons, and the court ordered accordingly. It is a simple case the issues were fully and efficiently briefed in one round of written submissions, and neither state wished to expend more time and resources on unnecessary further work. Permitting intervention, however, would slow down both cases and require additional resources to be devoted to this case. It would also increase the burden on the court. For those undesirable consequences to be justified, the court would have to be confident that an intervention by Guatemala would serve some useful purpose. For all of those reasons, although Belize does not object to Guatemala's application, Belize has sought to assist the court by identifying a number of quite fundamental issues with it. Guatemala has the burden of satisfying the court that the court should permit its application. Having listened to Guatemala over the course of this hearing, it is not at all obvious that Guatemala has satisfied that burden. I turn now, members of the court, to matters that would arise if the court were to permit Guatemala to intervene. The first is that Guatemala's agent expressed Guatemala's desire for a prompt and complete resolution of the cases before the court. Guatemala's agent added that Guatemala is equally eager, that is, equally with Belize, to reach a complete resolution of the territorial, insular and maritime delimitation dispute between itself and Belize. The agent did so with explicit reference to the special agreement founding the court's jurisdiction in Guatemala, Belize. Belize proceeds on the same two bases: prompt and complete resolution of the two disputes. The second matter is that any intervention would need to be limited to what Guatemala described this morning as matters that have not arisen in Guatemala, Belize. The third concerns timing. Guatemala suggested that 2 months may not be enough for it to make any further written submission that may be permitted. It did not explain why. Guatemala made its application to intervene almost 2 years ago and has made clear that it considers it inevitable that that application will be accepted. Quite how 2 months, in addition to those 2 years, would not be enough is another unexplained mystery. What is clear is that there need not be any further procedural conference with the parties, and the court could simply set the timeframes without further ado. Belize considers that they should be as short as possible, consistent with procedural fairness, and that 2 months is more than sufficient in all of the circumstances. President and members of the court, we thank you for your attention and invite you now to give the floor to the agent of Belize.
I thank Mr. Juratovic for his statement. I now call the agent of Belize, His Excellency Mr. Assad Showman, to the podium. You have the floor, sir.
President and members of the court, I wish to express our gratitude to you for your diligence and kind attention throughout this hearing, and more generally, in the 2 cases to which Belize is presently a party. I wish to thank the registrar and the registry staff for their cooperation and professionalism that has ensured the smooth running of this hearing. Thanks to the interpreters who have translated the presentations of each side so well, and to the court reporters for efficiently producing the verbatim records. I also wish to convey to the agents of Honduras and Guatemala Belize's appreciation for the cordial and cooperative atmosphere between the teams in these proceedings, reflecting the friendly and constructive relations between our three countries. Article 60, paragraph 2 of the Court's rules states that at the conclusion of the last statement made by a party at a hearing, its agent shall read that party's final submissions. As set out in the signed document, which I will shortly submit to the registry, and in accordance with Belize's oral submissions, I confirm that Belize does not object to Guatemala being permitted to intervene in this case pursuant to Article 62 of the Code statute. I thank you for your kind attention. This brings Belize's oral submissions to their conclusion.
I thank the agent of Belize for the conclusions presented on behalf of his government. This brings to an end the second round of oral argument of Belize. We will now hear the second round of oral argument of Honduras. I now give the floor to Professor Alejandro del Valle Garvez. You have the floor, sir.
Mr. President, distinguished members of the Court, it is an honor to appear before you again on behalf of the Republic of Honduras. Before replying to the arguments of Guatemala and Belize, allow me to make three preliminary remarks. First, Guatemala carries the burden of demonstrating that its application meets with the intervention requirements provided for in Articles 62 of the Statute and 81 of the Rules of Court. However, we cannot express our concern with the fact that Guatemala has mainly used these hearings to discuss questions of substance relating to the Guatemala-Belize case, which are foreign to the Sapodilla case. Second, in the interest of the sound administration of justice, Honduras will devote this round to reply exclusively to those issues relevant to these incidental proceedings. In accordance with the Statute of the Court, we will not discuss topics which belong to the merits of the Sapodilla case. Counsel for Belize have already indulged themselves enough on these topics. These hearings are not the proper forum to discuss them, as you declared in the case concerning the territorial and maritime dispute Nicaragua-Colombia. Honduras will address them when it is procedurally adequate. We are not in that stadium processus. In any case, we invite Guatemala and Belize to read the Honduran counter-memorial carefully. Our documentary evidence amply demonstrates Honduras' sovereignty over the Cayes Sapodillas. And third, under no circumstance should our position on this matter be considered as a concession by Honduras to any of the arguments presented by Guatemala and Belize during these hearings. Honduras will limit its response to the core issues of Guatemala's application. At the outset, Honduras confirms its opposition to Guatemala's application for permission to intervene. Considering the particular circumstances of this case, which Guatemala and Belize accept, Honduras maintains that this application cannot be granted for two reasons. First, the intervention requirements are not met. Second, this application dangerously undermines several principles of international procedural law. It triggers disruptive effects on the institution of intervention as recognized by the statute and the court's practice. Counsel for Belize suggested yesterday that the court could grant intervention to Guatemala on a conditional or restricted basis. Honduras opposes to even granting Guatemala such a restricted intervention. In land, island, and maritime frontier dispute, El Salvador, Honduras, Nicaragua exceeded the boundaries laid down by the court when exercising its right to inform the court, as recognized by your judgment of 1992. Honduras is not speculating. On Monday, Guatemala clearly expressed their intention to follow that example. And just this morning, they requested extensive time to prepare their case if this application were granted. They clearly are requesting a third round of written pleadings with Belize. The practice of the court offers procedural mechanisms other than intervention, which are very much in line with the general principles of procedural law. Indeed, the court can adopt a common action to ensure that both cases run harmoniously. Professor Jiménez Piernas will take the floor in a few minutes to put these procedural alternatives in plain words. Until then, I will reply to the arguments presented by Guatemala and Belize. First, Mr. President, let me explain why Guatemala's application does not meet the substantive intervention requirements, addressing three main points. My first point concerns the interplay between the absence of any documents in support of Guatemala's application and the interpretation of the substantive intervention requirements. For the purposes of these incidental proceedings, Guatemala completely disregards the existence of two parallel and separate cases. Guatemala's approach to this application is one-dimensional. Honduras maintains that the court should consider this formal defect in the analysis of the substantive intervention requirements. The absence of any document support of Guatemala application cannot be examined in isolation. Conversely, it demonstrates that Guatemala already enjoys protection and already has informed the court on any alleged interest. Mr. President, my second point concerns with the interest of a legal nature. Guatemala asserted that both Belize and Honduras acknowledge the existence of a legal interest, although it understands that Honduras does so with some hesitation. According to Guatemala, both the existence and the nature of the legal interest are well identified. Guatemala supports this assertion with an incomplete quotation from the case concerning the territorial and maritime dispute, Nicaragua, Colombia. They excluded the following, and I quote, "But this is not just any kind of interest of a legal nature. mais il ne s'agit pas de n'importe quel intérêt d'ordre juridique. End of quote. This court has stipulated that it must be a qualified and relevant interest. Guatemala's approach to this intervention requirement is dogmatic and clearly divorced from the specific circumstances of this case, which are defined by the existence of two parallel cases. Counsel for Guatemala asserted this morning, and I quote, "That argument is irrelevant," end quote. On the contrary, accordingly to the court's jurisprudence, this fact is essential for understanding the complexity of this incident. Contrary to Guatemala's assertion, Honduras does not merely insinuate, but openly denies the existence of a legal interest. This interest must be precise, specific, and well established, in accordance with the only 3 precedents in which intervention has been admitted. These 3 cases confirm that the interests of a legal nature were pre-established by judicial decisions, as Professor Jiménez Piernas explained. More importantly, any alleged interest cannot be affected by a decision of the court in this case. Yesterday, my colleagues, Professors Jiménez Piernas and Pascual Vives, demonstrated that Guatemala is protected because it has already informed the court a volonté. The judgment in the Sapodilla case cannot affect Guatemala. Considering the circumstance of the case, there is no interest of a legal nature which may be affected. Mr. President, I will now present my 3rd and final point, which concerns the object of the intervention. Honduras would remind the court that the circumstances in this unique case are incomparable with other previous applications for interventions before the court in which Honduras has participated. Guatemala asserts that it only wishes to inform the court and does not request in its application a ruling on its claim in the Gulf of Honduras. But this rhetorical acknowledgement of its procedural status as a non-party in the Sapodilla case is inconsequential to the question of whether the object of its application to intervene is proper and precise. Throughout these hearings, Guatemala has expressed its fears, to borrow an expression used by Judge Ago more than 40 years ago. Guatemala argues that the judgment in the Sapodilla case may affect its claims in the Guatemala-Belize case. However, Article 59 of the Statute and the Guatemala-Belize case offer enough protection to Guatemala. In fact, Guatemala's alleged interests enjoy a double layer of legal protection. Belize shares our views on these topics. Honduras did not apply for intervention in the Guatemala-Belize case, but benefits from the same protection because of the interplay between Article 59 of the Statute and your future judgment in the Sapodilla case. The existence of 2 parallel and separate cases before the court grants an additional layer of protection and makes this application superfluous, unnecessary. Moreover, Honduras considers that Guatemala's application causes disruptive effects. Given the circumstances of the Sapodilla case, this application constitutes a procedural anomaly. It is not only inconsistent with principles, with the spirit of the institution of intervention, but also contrary to the general principles of procedural law. As you said in land, island and maritime frontier dispute, El Salvador, Honduras, these principles ensure a proper conduct of judicial proceedings, as they are at the heart of any application for intervention. This brings me to my second point. Guatemala's applications runs counter to the general principles of procedural law. Mr. President, Guatemala's application is causing an unjustified delay in the Sapodilla case, and is contrary to the principle of the sound administration of justice. In the interest of celerity, Honduras has cooperated with the court to expedite the procedure in the Sapodilla case. It agreed with Belize not to appoint ad hoc judges in this case, despite the objective advantage to Belize of having appointed an ad hoc judge in the Guatemala-Belize case. Furthermore, pursuant to Article 45, paragraph 2 of the Rules of Court, Honduras left it to the discretion of the court to decide whether the parties in this case should submit a reply and rejoinder. It did not avail itself of its right to request a second round of written pleadings. Mr. President, the principle of judicial economy has a tradition in your jurisprudence. It was recognized in the Mavromantis case, and was later enshrined by this court in the case concerning the Genocide Convention, Croatia-Serbia, where the court said that this principle seeks, and I quote, to prevent the needless proliferation of proceedings, end quote. This application is contrary to the judicial economy of means. In deciding on an application for permission to intervene, as the court said in territorial and maritime dispute, Nicaragua-Colombia, the court is, and I quote, responsible for safeguarding the proper administration of justice, end quote. Strictly speaking, Guatemala's application is a misuse of this procedural institution. It is therefore contrary to the principle of the sound administration of justice. Mr. President, Honduras' opposition to Guatemala's application is based on these grounds. First, the arguments that Guatemala raises in its application have already been presented in the Guatemala-Belize case. Guatemala distorts the institution of intervention because it does not inform on anything new to the court. If Guatemala wanted to provide new information, it would have done so in that case, in accordance with the procedures set out in the rules of court and the special agreement. Second, Guatemala has the opportunity to use the oral hearings in that case to inform the court on any additional issues it deems appropriate. Third, Guatemala is using a procedural resource in violation of the purpose for which it was created. Fourth, Guatemala's application is a veiled attempt to open new litigation avenues. For that, they are already closed, a third round of pleadings against Belize, or even litigation avenues that cannot be opened, such a new dispute against Honduras. And fifth, there are practical arrangements and common actions which could be adopted by the court that would ease Guatemala's otherwise baseless fears. To conclude, Honduras is aware that the court faces a complex task because of the existence of two pending parallel cases. The court will render separate judgments in the Guatemala-Belize case on the one hand, and in the Sapodilla case on the other. These judgments can strike a balance between the two principles, the one relative of the effects of the court's judgment, set forth in
Article 59 on the statute, and res judicata envisaged in Article 60 of the statute. Honduras believes that these objectives can be attained respecting the sound administration of justice and judicial economy. We reaffirm that Guatemala's intervention is not the adequate legal avenue to achieve these goals. The court can explore other alternatives already settled in its practice, as Professor Jiménez Piernas will explain. Mr. President, Guatemala intends to run with the hare and hunt with the hounds. Guatemala ne peut pas être au four et au moulin. Or, as they say in proper Spanish, Guatemala no puede estar en misa y repicando. For all these reasons, we consider that this application must be dismissed in limine. Mr. President, distinguished members of the court, this concludes my presentation. Thank you very much for your kind attention. I would be very grateful, Mr. President, if you please call Professor Jiménez Piernas to the podium.
I thank Professor Del Valle Garves for his statement. I now invite Professor Carlos Jiménez Piernas to address the court. You have the floor, sir.
Mr. President, distinguished members of the court, during the present hearings, Honduras has explained in detail that Guatemala's application is pointless and unnecessary, and furthermore does not meet the necessary conditions for intervention as set out in the statute and the rules of the court. With utmost respect, and without intending any slight towards the court, Honduras would like to suggest to the court that it avail itself of some procedural tools that are compatible with the sound administration of justice and the economy of procedure. Practical arrangements
that might possibly assist the court in gathering information on all aspects that may be of interest to it, that are connected with the two proceedings being conducted in parallel. Honduras considers that it is important to apply these tools in the current proceedings for three reasons. First, these incidental proceedings are unique on account of the existence of two pending parallel cases before the court. Second, because these are procedural tools that are enshrined in the court's practice. And third, because these are instruments that are consistent with the principles of the sound administration of justice and the economy of procedure. Allow me to give further explanations. Mr. President, Article 94, paragraph 2 of the court's rules states, and I quote, "The judgment shall become binding on the parties on the day of reading. End of quote. For the judgments in the Guatemala-Belize case and the Zapotilla case can produce the effect of rex judicata in a harmonious manner, the court could render these judgments on the same day. This course of action would not require adjoining the proceedings and would allow the cases to be conducted in a manner that is both separate and coordinated up until the reading of the judgments. The court followed this practice in the following cases: fisheries jurisdiction, nuclear tests, Lockerbie, legality of the use of force, appeal regarding jurisdiction of the ICAO Council under Article 84 of the Convention on International Civil Aviation, and finally, application of the International Convention on the Elimination of All Forms of Racial Discrimination. If the court were to choose such a course of action, it would assuage one of the main fears that Guatemala is alleging, albeit unjustifiably, in its application, namely that the protection afforded by Article 59 of the statute is, according to it, insufficient against the judgment that will be handed down in the Zapotilla's case. Guatemala, through a strained interpretation of some precedents, is claiming that the protection under Article 59 of the statute is not always sufficient. Honduras believes that this concern is not justified in the present case in light of the special circumstances of the case, and this for two reasons. First, as a general principle, you must always take into account the existence of other states that have claims in the region, and secondly, in this particular instance, the existence of two parallel pending cases before the court make it incumbent upon it to take into account even more so the interests or rights that are being alleged by all parties, including, of course, those of Guatemala. The court will take into consideration all of the information that will have been provided by the parties in connection with the two disputes during their deliberations on the two proceedings. The information provided during the written phase and the information provided during the oral hearing, which is ongoing. Thus, nothing would preclude the court from taking into consideration the information that are provided to it at this stage of the current incidental proceedings. Whatever the court's decision on the application, Guatemala has already achieved something that is significant. The court will bear in mind, in the Zapatilla's case, the documents filed in connection with the Guatemala-Belize case that Guatemala deems to be relevant. These documents seem to be important for Guatemala, and the court, no doubt, will consider said documents at the appropriate time. During these hearings, Honduras has contributed to facilitating the court's work. Indeed, we have shown the parts in the memorial and the reply of Guatemala where the answers to its concerns can be found. The coordination and the coherence between the two cases is an objective that is shared by Honduras and by Belize as well, even if in a more tentative and ambiguous way. Honduras is not opposed to allowing the two disputes to inform one another. Indeed, in the name of the principle of the sound administration of justice, Honduras relied upon, in the Zapotilla's case, some of the documents in the case file of the other proceedings. I am referring, for instance, to a document dated August 11th, 1835, that was submitted by Guatemala. This document proves, let us not forget, that the Spanish crown never ceded to the British crown the sovereignty over those territories located on the eastern coast of Yucatan, thus disproving one of Belize's main arguments. Honduras believes that it is not necessary to include, again, as an annex in the Sapodilla case, this document, because Guatemala has already introduced it in the other proceedings. We hope that the court will be able to take this duly into account in its decision. If the court were to hand down the two judgments on the same day, this would provide a solution in keeping with the principle that enshrines the relative effects of the court's judgments and the principle of rex judicata. Furthermore, this course of action would be fully consistent with the principles of the sound administration of justice and economy of procedure that have been raised so many times during this hearing.
Moreover, Article 48 of the statute gives extensive powers to the court so that it can make, and I quote, all arrangements connected with the taking of evidence, end quote. This should be read in conjunction with Article 61 of the Rules of Court, which enables the court to specify the contents of the oral phase. Thus, the court has the power to ask questions to the parties prior to and during the oral phase. In the case concerning military and paramilitary activities in and against Nicaragua, the court affirmed, in line with its jurisprudence, that it could inquire into the facts of a case. And it stated, and I quote, "As to the facts of the case, in principle, the court is not bound to confine its consideration to the material formally submitted to it by the parties," end quote. Should the court deem it necessary, it could request additional information from the parties prior to and during the oral phase of both parallel pending cases. This possibility must be exercised with discretion and due regard to the basic principles of procedure being afforded. And it could be broadened by taking into account Article 62 of the Rules of Court, which enables the court to, and I quote, call upon the parties to produce such evidence or to give such explanations as the court may consider to be necessary for the elucidation of any aspect of the matter in issue, end quote. In short, Guatemala already has copies of the documents and of the annexes in this our dispute and may comment on them during the oral phase of the Guatemala-Belize case. Moreover, the court could invite Guatemala to submit observations on relevant aspects of this case during the oral phase of the Guatemala-Belize case. Article 72 of the Rules of Court would allow Belize to respond to any observation made by Guatemala in Guatemala-Belize under Articles 61 and 62 of the Rules of Court previously mentioned. All in all, these rules and principles to be found in the statute and rules of the court can serve to initiate a productive information dialogue between these parties, between both cases, which would inform each other. There is no doubt that it gives the court the discretionary power to request information from the parties should it deem it necessary. Mr. President, let it be said at this point in time that Guatemala, Honduras, and Belize have not called for the cases to be formally joined. Honduras considers that the necessary criteria to join both proceedings are not met. It is, in fact, such joinder is, in fact, an exceptional practice that relies on the agreement of all parties. And Belize also objects to joining both proceedings when it says the following, and I quote, "Each of the two disputes concerning sovereignty over the Sapodilla Cayes between Belize and Honduras and between Belize and Guatemala, respectively, can be dealt with as between the parties to each case, consistently with Article 59 of the Statute of the Court," end quote. Honduras holds that the court may use alternative involving a common action in accordance with Article 47 of the rules. Such procedural means or approaches would be outside the scope of intervention and would give the court greater margin for appreciation. Thus, it would be possible to rely on procedural practices which would enable both cases to further inform each other should the court deem it necessary. For instance, the court may wish to, firstly, schedule the oral hearings one after the other, with enough time, of course, between the two.
It is understood that the hearings in this case would always occur second, after the hearings in the Guatemala-Belize case. And secondly, the court may organize deliberations in such a way as to avoid any confusion between the two disputes, as they are, in fact, of a different legal nature and have distinct reach or scope. In other words, these are different cases. Any such measures adopted by the court to exercise a common action would be consonant with the principles of the sound administration of justice, I'll say it again, and of judicial economy. Moreover, they also give the court a significant leeway to conduct both proceedings in a coordinated fashion. They would give the court the flexibility that is not found in Article 62 of the statute and 81 of the rules. The application by Guatemala would have the court be flexible of all the criteria for intervention. It may have shown some flexibility with the formal criteria, but it has never shown flexibility for the two substantive criteria, namely the interest of a legal nature affected and the object of the intervention. Honduras submits that flexibility in interpreting all criteria of intervention is unacceptable. It would, in fact, change the institution of intervention. This altogether too permissive approach is both irregular and improper. And on this, Honduras agrees with the opinion that I have just referred to and which was voiced a few years ago by Professor Pele, now counsel for Guatemala. Moreover, the flexibility which Guatemala is seeking may be secured through other rules found and principles found in the statute and rules of the court. For instance, through the adoption of practical arrangements compatible with the applicable law. The court may thus initiate
common action to tackle the unique challenges related to intervention due to there being two parallel pending cases. Such practical solutions offer a reasonable balance between the baseless claims Guatemala wishes to argue thanks to intervention on the one hand, and the general legal principles of international procedure. In short, the claims of Guatemala go well beyond the letter and the spirit of intervention, insofar as they seek to extend the dispute in Guatemala, Belize, into this dispute. And in light of the proceeding, Honduras submits and considers, one, that there is no reason to have an overinterpretation of intervention in the Sapodilla case. Secondly, there are other ways for Guatemala to inform the court by means that would be more mindful of the bilateral nature of each case and of the principles of the sound administration of justice and procedural economy that do exist. Thirdly, the court may adopt practical solutions to secure additional information from the parties whenever it deems it necessary for consistency in the resolution of both disputes. Lastly, during the hearings, Belize proposed, and we welcome it, that the cases, both cases, be coordinated, and this could be a procedural solution acceptable to all parties. I do hope that this will also comply with the standards and principles set out this morning by Sir Michael. Mr. President, members of the court, this brings my intervention to a close, and I'd like to thank you for your kind attention, Mr. President. And I request that you give the floor to the agent of Honduras, Ambassador Licona, who will read out Honduras's final submissions. Thank you.
Ms. Pernas to address court. I now give the floor to the agent of Honduras. You have the floor, madam.
Monsieur le Président,
Mr. President, members of the court. With your leave, sir, I have the honor to submit the final submissions of Honduras as concerns the application filed by Guatemala. In accordance with Article 60 of the Rules of Court and taking due account of the application for permission to intervene submitted by the Republic of Guatemala and of its pleadings, the Republic of Honduras argues the following. The application submitted by the Republic of Guatemala is unnecessary and is an abusive use of intervention. It must therefore be found inadmissible in limine. Moreover, Guatemala has not met the criteria set by the statute and the rules of court, that is, Articles 62 and 81, respectively. Honduras, 1, is opposed to any such permission being given, and 2, request the court reject the application for permission to intervene as submitted by Guatemala. A signed copy of our final submission has been submitted to the court. Mr. President, as I conclude our participation in the oral proceedings, I should like to, on behalf of the Republic of Honduras and of our entire delegation, I should like to express our heartfelt gratitude to you, Mr. President, and to each and every member of the court for the kind attention afforded to our presentations. I should also like to thank the registrar and his team and the interpreters for their help over the course of these hearings. Lastly, let me also thank the delegations of Guatemala and Belize and their councils for the courtesy that has prevailed over the course of our hearings. Thank you, Mr. President. Thank you, members of the court.
I thank the agent of Honduras, Her Excellency Ms. Patricia Licona, for her statement and for the conclusions presented on behalf of Honduras. That brings us to the end of the oral proceedings on the application of Guatemala for permission to intervene in the case concerning sovereignty over the Sapodilla Cayes, Sapodillos, Belize versus Honduras. The court has taken note of the conclusions submitted by Guatemala and the parties. I should like to thank the agents, counsel, and advocates for their statements. In accordance with practice, I shall request the agents of the parties and agent of Guatemala to remain at the court's disposal to provide any additional information it may require. The court will now retire for deliberation. The agent of the parties and the agent of Guatemala will be advised in due course of the date on which the court will deliver its decision. As the court has no other business before it today, the sitting is closed.